Colorado is now home to one of the most restrictive gun laws in the country.
New restrictions on some semi-automatic guns sales take effect today.
It restricts the purchase of semi-automatic firearms with detachable magazine.
There will be new requirements to buy certain types of guns.
They infringe on Second Amendment rights.
It's a horrendous infringement on our God-given right to purchase firearms.
In the span of just 30 days, nearly 60,000 people rushed into local gun stores across a single American state, causing state background check servers to crash, setting an all-time historical sales record, and creating panic that stretched from local gun shops all the way to state law enforcement headquarters, while most people were completely unaware of what was quietly happening behind legislative doors. A massive legal shift landed with absolute force, fundamentally altering the reality of firearm ownership for millions of Americans. What just took place in Colorado is not merely a local state policy change or another standard piece of gun legislation. It is the real-world deployment of a completely untested regulatory blueprint designed specifically to bypass federal court challenges, bypass standard constitutional roadblocks, and redefine how Second Amendment rights are exercised across the country. To fully understand why thousands of citizens rush to buy every available semi-automatic rifle off store shelves, you have to look at what Senate Bill 25-03 actually does. For decades, gun control strategy in the United States relied on direct, outright bans on specific cosmetic features or firearm models. State legislatures would draft lists of banned semi-automatic platforms, define prohibited physical attributes, and attempt to outlaw entire classes of firearms. However, following recent landmark rulings from the United States Supreme Court, particularly decisions establishing strict historic tradition standards for firearm regulation, direct bans have consistently run into immediate federal court injunctions and constitutional strikes. Recognizing that direct prohibitions face near-instant legal blockage in federal courts, lawmakers crafted an entirely different approach. Rather than banning the physical firearm itself, they built a complex, multi-tiered bureaucratic gauntlet that makes acquiring one virtually impossible for the average citizen. Under this newly implemented framework, standard point-of-sale background checks are no longer the final step in purchasing a common semi-automatic rifle, semi-automatic shotgun, or gas-operated handgun with a detachable magazine. Instead, the entire purchasing process has been flipped upside down. Before an individual can even step into a retail gun store to select a rifle like an AR-15 platform or any of its hundreds of variants, they are required to initiate an extensive pre-purchase licensing process. This means a law-abiding citizen must first submit a formal application directly to their local county sheriff. But the application itself cannot move forward until the applicant personally arranges and pays for a separate, name-based background check through state-approved third-party vendors. These third-party vetting fees, ranging anywhere from $50 to over $200 out of pocket, are entirely non-refundable, regardless of whether the permit is granted or delayed. Once the third-party background documentation is secured and delivered to the sheriff's department, the applicant enters a deep administrative waiting period. Unlike standard concealed carry permit frameworks that enforce strict statutory deadlines for processing, this new pre-authorization scheme gives local authorities unrestricted time to review applications, meaning processing times can stretch on for months depending on county resources or political alignment. If an applicant manages to navigate this first phase and receives a temporary eligibility card, they are still prohibited from making a purchase. The card merely grants them legal permission to register for a mandatory state-mandated firearm safety course. This educational requirement introduces another massive layer of friction. For individuals who already hold a valid state hunter safety certification, the law mandates a 4-hour instructional course. However, for every other citizen, the state requires a comprehensive 12-hour curriculum that must by law be spread over 2 separate calendar days.
Now, buyers must first get an eligibility card from their county sheriff.
Gun safety is important, and it starts at home. You should train your children in the use of firearms.
Under the new law, it is illegal to buy, sell, and make most semi-automatic firearms without background checks and training.
Anyone who buys one of these guns will have to apply through the state's firearm safety system, which went live last week.
Finding certified instructors who teach this exact state-approved curriculum has proved to be an immediate operational bottleneck. With hundreds of thousands of potential buyers statewide and only a small fraction of certified trainers operational, waiting lists for these required 2-day classes are already stretching well into the future. Once a citizen completes the multi-day course, receives official state certification, and finally walks into a licensed retail store, the standard purchasing routine begins from scratch. The buyer must undergo the standard state and federal point-of-sale background checks through the State Bureau of Investigation, pay the mandatory retail transfer fees, and then observe a mandatory 3-day statutory waiting period before taking possession of the firearm. From initial application to final delivery, what was once a standardized retail transaction has been converted into a multi-month, multi-$100 administrative ordeal involving multiple state databases, third-party vetting vendors, local sheriff departments, and mandatory classroom attendance. The immediate real-world fallout from this legislative transformation became strikingly clear in the weeks leading up to the law's official enforcement date. As the deadline approached, citizens across the state realized that buying a standard semi-automatic rifle would soon require navigating an unprecedented maze of bureaucracy. The resulting market reaction was unprecedented. The State Bureau of Investigation's InstaCheck background system was overwhelmed by an incredible surge in demand. Official state data revealed that during July alone, state officials processed 59,452 firearm background checks. To put that massive figure into perspective, during the exact same calendar month in the previous year, the state processed just over 20,000 checks. Sales nearly tripled overnight, as single-day background check processing records were shattered repeatedly, far exceeding even the busiest Black Friday shopping days in state history. State agency personnel had to double their background processing staff, mandate continuous overtime, and run processing operations around the clock just to prevent the required 3-day system queue from completely collapsing under the weight of historic consumer demand. While gun control advocates and state legislative sponsors openly celebrate the law as a monumental victory, describing it as an effective operational end run around traditional firearm manufacturing, Second Amendment legal scholars and advocacy organizations view the framework as something far more strategic. Lead legislative sponsors openly acknowledge that this statutory mechanism accomplishes the functional goals of a complete firearm ban without technically issuing a flat statutory prohibition. By creating a system where the right to acquire a firearm is gated behind administrative delays, third-party vendor fees, mandatory multi-day classes, and discretionary agency processing, the state has built what legal analysts refer to as an operational barrier to constitutional rights. What makes this development critically important for citizens living far beyond Colorado's state borders is the intentional, scalable nature of the legislative design. Policy legal teams behind this bill created it explicitly as a master template for other state legislatures across the nation. For years, states seeking strict firearm regulations faced immediate federal court injunctions whenever they passed direct equipment bans. However, by shifting the mechanism from equipment bans to pre-purchase licensing frameworks, lawmakers have exploited an ambiguous legal area within federal jurisprudence. In recent Supreme Court precedent, specifically the landmark Bruin decision, the court included brief discussion notes regarding state licensing regimes, suggesting that routine, objective licensing requirements like background checks or basic safety courses could remain constitutionally permissible. State lawmakers strategically seized upon those specific notes, crafting Senate Bill 25-003 to test the extreme outer boundaries of what federal courts will allow under the guise of objective licensing. Because this framework is built to exploit those specific legal loopholes, gun control advocacy groups and legislative coalitions in several other states are already drafting identical language for their upcoming legislative sessions. States like California, New York, New Jersey, Massachusetts, Connecticut, Maryland, Illinois, Delaware, and Washington state that previously had their traditional firearm bans struck down or severely challenged by federal judges are now preparing to introduce this exact multi-tiered pre-purchase permit system. If this regulatory structure survives initial legal challenges in federal court, it will instantly spread to dozens of other states, fundamentally changing how firearms are acquired across nearly half the country. Under this expanding model, purchasing popular semi-automatic rifles will no longer depend on whether a firearm is legal to possess, but whether an individual has the time, financial resources, and patience to endure months of administrative processing just to obtain state permission. As the implementation unfolds, local law enforcement agencies across Colorado are already voicing severe concerns regarding operational capacity. Sheriff departments in rural and mountain counties have publicly reported that they lack the administrative staff, technical infrastructure, and dedicated funding required to process thousands of incoming pre-purchase applications review third-party background files, and issue state eligibility cards. Out of 64 counties, only a small fraction had established clear operational processing protocols when the law took effect, leaving citizens in many jurisdictions in complete legal limbo with no clear path to apply for permits locally. This operational paralysis has forced buyers to travel hundreds of miles to neighboring counties that possess the staff required to process out-of-county applicants, adding even more financial expense and travel time to an already burdensome process. Furthermore, firearm retailers across the region are facing unprecedented economic disruption. Small business owners, gun store managers, and independent licensed dealers are witnessing a sudden artificial freeze in supply lines and consumer sales. Retailers who relied heavily on standard semi-automatic rifle inventory, related accessories, optics, and target ammunition are finding their primary business models completely upended overnight, because the average law-abiding consumer must now wait months just to receive their initial eligibility clearance. Retail foot traffic in many parts of the state has dropped drastically following the initial purchasing panic. Many family-owned firearm businesses report that they may be forced to shut their doors permanently before the legal challenges make their way through the slow federal court system, creating a long-term chilling effect on the commercial gun industry as a whole. The wider economic fallout also extends directly to state conservation funding and wildlife management programs. In the United States, a significant portion of state wildlife conservation funding is generated directly through federal excise taxes levied on the sale of firearms and ammunition under historic wildlife restoration acts. When state legislation effectively freezes firearm retail transactions through administrative gridlock, federal tax revenues generated from gun sales collapse proportionally. Wildlife management agencies, state park authorities, and local conservation initiatives that depend on these critical funds are warning of severe multi-million-dollar shortfalls, revealing how deep and unexpected the ripple effects of high-intensity gun legislation can actually be. Meanwhile, national Second Amendment legal organizations, coalition groups, trade associations, and individual gun owners have launched immediate legal action, filing comprehensive federal lawsuits challenging the constitutionality of the new licensing requirement. Plaintiffs argue that requiring citizens to pay non-refundable fees to third-party vendors, attend mandatory multi-day state classes, and wait indefinitely for discretionary local administrative approval before exercising a fundamental constitutional right violates core Supreme Court precedent. The legal battles now moving through federal courtrooms will likely determine the future of gun ownership in America. If federal courts uphold Colorado's pre-purchase permitting framework, the model will rapidly become standard law in dozens of states overnight. If federal judges issue injunctions, it will establish clear constitutional limits on how far states can go in restricting access through administrative hurdles. For now, Colorado stands as the primary testing ground for the newest and most sophisticated strategy in the national firearm debate. What began as a local legislative push has transformed into a high-stakes legal blueprint that is reshaping consumer behavior, breaking historical state processing records, devastating local commercial markets, and setting up a monumental showdown before the United States Supreme Court that will dictate the future of the Second Amendment for generations to come. That's it for today, folks. See you in the next video.